court, I'm required to be honest. You had enough for a probable cause for an indictment, not enough for maybe for proof beyond a reasonable doubt, which is trial standard. So that's what I took his testimony to believe in terms of, sure, he could have sought an indictment at 18, but that's not, I mean, but ethically as a prosecutor, you don't want to necessarily indict and then search for evidence. That's not how it works. You have to have certainly, you can certainly develop other evidence and whatever, but he's telling you that from the strength of the case that they had in 18, it wasn't enough.
But I don't think he said that about Mr.
I know he didn't say that, but that's what the court's going to extrapolate from his testimony.
Well, Your Honor, I'll back up a little bit. The purpose of constitutional speed is we're talking about they need time to develop. The purpose of constitutional speedy trials is they're supposed to develop before arresting someone and taking their liberty away. They're supposed to have a case. And the idea that they went and locked Mr. Stillwell up and now we're saying, oh, they didn't have enough.
They're talking about his co-defendant.
Yet at the same time, no one from the DA's office said, hey, we don't have enough to proceed on him, so let's drop him.
Remember what Mr. Sprinkle said. At some point in time therein, it developed that this homicide may be interrelated with a RICO case. And that's why they decided to go ahead and further develop in that particular issue. So I'm going to weigh the delay factor slightly against the state. Okay, let's move on to number 2, the cause of the delay.
Your Honor, I would just like to say that I would just like to stress it was 7 years and 2 months, and that they did not seek an indictment.
And you know what? They are, I think that that factor is going to weigh against the state, but it's only going to weigh against it slightly or not. Okay.
And I'll also point out, Your Honor, that the case law and just regarding delay, just for the record, Your Honor, the presumption of pretrial the prejudice from pretrial delay intensifies and compounds over time. And there are cases in Georgia where delays less than this. State v. Sutton, 7 years delay was egregious according to the state, and it removed the need to show particularized prejudice, which we have here. But I would just like to stress to the court that the delay is not, before we move on to the next thing, and I am going to move on, that the delay is not an isolated factor, but it also affects the ability to show the other factors.
I agree.
Okay. And that's,
I agree with you because it does affect it bleeds into the second factor and it bleeds into the third factor. So I understand, and I don't disagree with you in the least. Okay?
And so I'll move on to cause, and I think this is important because, Your Honor.
Okay, so I got a question for you.
Yes.
Do you think the state deliberately tried to delay your case?
I think they made a decision. They made a tactical decision, and Your Honor, in just asking.
Do you think that they deliberately delayed your case in order to hamper your defense? Because that's really the issue. Did they delay you to hamper your defense?
Well, Your Honor, I'm going to cite Hayes.
Now answer my question. Answer my question.
Did
they delay your case in order to hamper it?
There's 3 levels. There's not just 2.
Well, answer my question. Did they delay your case in order to hamper it?
I don't believe that they deliberately acted in bad faith. But I do believe that there's a middle ground under Hayes v. State 298. Georgia.
Okay, well, it's not negligence. They're not saying, well, hey, we had an overcrowded docket. He slipped through the cracks or anything such as that that's argued in many of these cases. So they told you, you may not like it, but they told you why it is that you that they they had a protracted investigatory period, let's just say on your case.
I would agree that there was a protracted investigatory period. I don't necessarily agree that all of that involved Shannon Stillwell. I believe that they had that case wrapped up in 2016.
Okay, so if I believe the state, which from their testimony, then that's certainly a reason that I could do it and it would justify that delay.
Well, I don't believe so. And
Why not?
I'm going to explain why. Well, first of all, we haven't heard.
Well, under Barker versus Wingo, that is what I'm supposed to look at.
I agree, but Barker v. Wingo has been.
So, but I mean, you have to show a deliberate attempt
I don't
to,
agree.
to go ahead and,
Your Honor, I
do
don't.
that.
Respectfully, I do not agree that I have to show a deliberate attempt. First of all, I don't believe I have to do so with such an extreme delay. But secondly, Your Honor, there is a middle ground.
Okay, but okay, let me rephrase. They have told you why it is it took them a protracted period of time in the Ticker case. They've told you through Mr. Sprinkle. More than proper. He's put his hand up and he said, listen, we had this homicide. We started to develop other information. There might have been retaliatory shootings in regards to this homicide. There might have been gang affiliation or gang activity related to that. And they didn't, and the interrelationship with those two aspects, as specified by Mr. Sprinkle, that would be a reason for them to justify the delay.
I respectfully, Your Honor, disagree.
Okay, we're going to have to disagree on that.
Well, and I'm going to say why. Because it was a deliberate, it was a decision. It was the decision they made that they wanted to put the 2015 case.
But what was the decision based on, sir?
Well, I will respond to that. First of all, Mr. Sprinkle made it clear he wasn't the one that made the decision. So we don't really know what the decision was based on. But it's clear to me.
Well, well, listen, from the testimony of this team, that they only have probable cause. They didn't have trial beyond a reasonable doubt, which is an ethical issue. Remember, Mr. Sprinkle says, I can't just indict something. I mean, that's why we get in this whole discussion all the time about ethical prosecution. Mr. Sprinkle had enough sense to tell you, hey, at that point in time, we're not indicting it because we don't have enough to be beyond a reasonable doubt. So
we're not indicting it. We just arrested him and had him in jail. And I mean, they are the ones that triggered it with the arrest. And the law requires them to pursue the charges once they make.
Do you think this is a complex case or a simple case?
I think it's a very simple case that they have chosen to make complex.
It's pretty complex.
Well,
you got 28 folks.
That's exactly my point.
You got a 65-page indictment. You have over, I think it is, how many counts do you have, Ms. Martin?
65-page indictment.
65
Wow.
counts.
And that's exactly what.
So I mean, it's not simple.
That's
That's big.
Looking at Howard versus State, 307 Georgia Appeal 822, 2011. You know, you got an allegation by the state of continuing criminal enterprise. You got the RICO issues. You got related. You got a homicide, and you got a lot of acts that the state has to investigate. There's a lot of work with this case. So I'm gonna say to you that this particular cause of the delay. I don't believe that the court is of the opinion, based upon what I've heard in terms of testimony, that the state intentionally delayed this case to hamper your defense.
But, Your Honor, I just want to make clear for the record, my point is not that they intentionally did it to hamper my defense. They made a deliberate
That's Young
tactical
Thug,
decision
co-defendant.
on State v. Shirley, 311 Georgia Appeals 141. It's a 2011 case. The state made a deliberate decision not to disclose the identity of a CI to the defense, which led to the lengthening of the time before trial. And what they say is gamesmanship is more than negligence. Hayes v. State, 298 Georgia Appeals 338. The state decided to dead docket a case and then call it back up years later.
Is that the case? Is that the case in this particular circumstance?
Well,
It's different in this case because they have continually tried to investigate it. So I'm
Thug right
let's
there by his
move
lawyer.
on to your assertion of the rights for your trial. I'll agree with your
Seems like
client
that beside
asserted
him.
his right to trial on at least 3 different occasions. Would
Like
you
a thug.
disagree with that?
and I would just ask that you would note that really the most important one is the first date, which was in 2019.
What date was that, sir? I have the 9 May 22 and the 5 August 22. What? Go ahead, July what?
July 2nd, 2019.
Okay, so he's at least asserted 3 times.
Correct.
So the court will go ahead and
And
Let me shout out to Law and
well,
Crime.
let me ask
channel.
you this question here, okay? So
Give a
incident
huge
that
shout out to the Law and
occurred
Crime
in
channel.
2015, October 27th, 2015. So he waited some 4 years or thereabouts, almost 4 years. I'm terrible at math, but almost 4 years to ask for that particular trial to be or assertion of the right to trial. 3 years and some months.
yeah, 3 years and some months. And it sounds like the state was making a point that he was in prison at that time. But, Your Honor, that case was unindicted. So he never had access to discovery. The case law says
Like, share, and subscribe,
that
man.
failure to disclose discovering is a mitigating factor in a delay to assert your constitutional speedy trial rights.
CMDAGOAT.
And when did they indict
See, I'm
the
the goat.
case?
Well after he asserted,
As relates to Mr. Stillwell.
they never indicted the murder.
Give a
By
shout out
itself.
to Law and
And
Crime
that's the
channel.
whole point. That it's a simple case that they make. Never indicted this murder case.
When did your client file a statutory demand for speedy trial, or did he ever file one?
He's never had an opportunity to.
Did he
To
ever
file one.
file one? No,
There's no,
okay.
Your Honor,
I agree.
on New Year's Eve at 12:01 a.m., after I kiss my wife under the mistletoe, I will file a statutory speedy demand. But there's no point in filing a motion, a demand that has no legal basis.
Look at
In
those,
fact,
y'all.
lawyers
Look
are
at that.
told not to do so. It's clear that there is no legal basis to file a statutory speedy trial demand at this time. If you want me to file one, I will.
I just want to make sure we understand one. Okay, you're good. You're good. Okay, so, all right, so,
But we've had these constitutional speedy demands in.
all right, should I weigh that factor against the state or against your client?
Well, I think that it's
The
neutral.
state's asking me to weigh it against you.
Well, of course they are.
Because you didn't ask for, your client never did assert the right to a speedy trial.
They wanted him to assert when he was in prison back in 2016, 2017, when I wanted them to indict the case. So, yeah, of course they want that, but again, it would be error of the court respectfully to fail to consider the mitigating factors of the failure to disclose discovery at State v. Buckner, 292 Georgia, 390 at 397. That's 2013, and delay in indictment is a mitigating factor, and that's Hester v. State.
Okay,
And
what's the assignment, Hester?
I'm going to get it for you, Your Honor. Yeah.
Does Hester talk about why the delay in indictment?
it was a vehicular homicide case. It was a 5-year delay. Well, more than 5 years, the defendant did not serve until after 5 years. And it was error for the court. The holding in this case was the trial court erred in denying constitutional speedy and dismissing the case. And the trial court erred in failing to consider mitigating factors such as the delay in indictment, and also in that case, which admittedly does not apply here, the failure of the defendant to be appointed an attorney in a timely manner, which may apply to other people in this case. So that was the facts of Hester v. State, but I would also
Shout out to Law and TV, Law and Crime, Law and Crime Channel.
Johnson has been both allowed to try to accuse must assert it to the court, and Henderson, that's it. Johnson's 291 Georgia, 863, pinpoint 866, and then Henderson is 310 Georgia, 231, pinpoint 237.
And in all respect to my colleagues at that table, I just, and I'm not saying that this just came up today and they were working hard on it. They gave me their brief today, so I haven't really looked at those cases. But I will say in their brief, they're arguing that, again, an impossibility, and I can't even believe that they're making this argument that I have failed to file a statutory speedy trial demand, which I know we discussed, but quite honestly, I think that they're.
You can't file something that's not there, so
Well, that's in a brief, so
I know.
skeptical.
And I'll be interested to see what Mr. Anderson, is it Mr. Smith? I'm sorry.
Armstrong.
Mr. Armstrong, I knew it was something. Oh, gosh. Mr. Armstrong, I'll be interested to see what Mr. Armstrong says about that, but we'll, all right, so tell me about your prejudice. That's the,
Well,
you argue oppressive pretrial incarceration and death of a witness. So, well, it's pretrial incarceration is presumed to be of harm to the defendant to begin with. So you can certainly.
I'm not going to focus on that, Your Honor.
Okay.
And so, but the point I would first make is actual prejudice, which I'm going to get to, that we do have in this case. But actual prejudice is not needed when the extraordinary length of delay raises a presumption of actual prejudice.
Okay, but I'm telling you.
After such a delay, the showing of actual prejudice is not needed, and that's Grizzard v. State, 301 Georgia Appeals 613, Redding v. State, 313 Georgia 730. That's a 2022 case. Hester v. State, which I've already cited. And the greater the pretrial delay simultaneously presumes and decreases the expectation that the defendant can demonstrate tangible prejudice to his or her ability to present a defense.
Okay, but here's the thing. The first thing is the state has given you a reason as to why the case took so long. So address for me, and you keep going back to that issue, but I'm telling you, like you said, the factors are interrelated. I have to decide that to begin with. So address for me the, whether that's your client's been prejudiced.
Well, Ms. Love, in her redirect, made my point.
Made you what?
Made my point.
Okay, all right.
They had this witness, Tremont Stillwell, who says that my client gave a third-party confession in the park in front of Vanetta Guffey. I think we would all agree that a third-party confession is pretty substantial, important evidence. I don't think anyone would disagree on that. If they disagree on that, they can choose not to enter any third-party confessions. So Mr. Sprinkle, in following up, doing what he's supposed to do to investigate, brings in Miss Guffey. Miss Guffey, Mr. Sprinkle testified to this on cross. She said two things. Mr. Stillwell, meaning Tremont Stillwell, her husband, I believe it's actually like a common law husband thing, is a liar. That's one thing she said. And two, she denied being present at any conversation, any confession, anything involving Shannon Stillwell.
Look at thug, y'all.
Okay, she pushes back and becomes a
It's actually
defense
live.
witness that would impeach Termon Stillwell. I think that's pretty clear. Somehow, and now she's no longer with us, sadly, and she's not available as a witness. Somehow, the prosecutors in this case, they just showed their hand. Somehow, her saying, I don't know anything about it, it never happened, and storming out has become evidence that somehow she knew about this homicide and associates Shannon Stillwell with the homicide. And now we're speculating and inviting speculation from presumably the jurors at some point about all this stuff. And all I want to do, call Miss Guffey to the stand. All they want to do is twist everything that happened in that room into the worst light possible to aid in their case, which they delayed in bringing, and which Miss Guffey passed away tragically during their delay. And that is the exact problem. That's the exact problem. I want that live witness.
Okay.
And Your Honor, and
Well,
I will say,
we don't know whether or not the state's gonna call,
well, they
that
have
Ticker Stillwell. And, you know, whether or not that's gonna be relevant at that point in time. They also gonna have to have it in the correct form that even have it admitted. So it's really dependent upon a lot of things that may or may not occur in this particular case. So,
and Your Honor, I will also, I don't think Your Honor disputes that the unavailability is in dispute here. I think that's obvious. I think the prejudice is obvious. To a degree of prejudice,
but the state didn't cause the unavailability. You agree with that, right?
I don't think they literally killed.
No, I
Miss
mean, she
Guffey, no.
died of natural, but she died of a natural cause. She had an aneurysm. Is that correct? Okay, all right. Can you ask me one more thing going back to the
So she
prejudice?
had an
Was she caught in
aneurysm.
jail for anything during that particular period of
Thug
time?
might be coming on,
Ongoing
y'all.
charges?
I cannot. I defer to Department of Correction records on that. Are you speaking to the 254 days that were discussed?
Well, I'm talking about the period of time, probably from 2016 to the time of the indictment. Was your client serving any other time in custody for any other offenses? I'm only asking for that because it makes a difference in the analysis.
I would defer to the Odyssey jail records on
Okay.
that.
But
I think that there's likely periods of incarceration in all candor to the court. But Your Honor, I would like to also point out that that Hester case that I cited also makes it clear that the impact of a live witness testifying from the stand with the jury able to determine the witness's demeanor and credibility is what is important. And a transcript and a tape recording is not the same thing. We want to have the jurors be able to compare the demeanor and reliability and believability of Termon Stillwell versus Vanetta Guffey. And we have been denied that through this delay. You know, I know Your Honor's going to find out how Your Honor finds. But again, I would
I
just...
gotta follow the factors, the four factors.
And I understand, Your Honor, but I just would like to stress, while I'm not saying that they knew she was going to die, what I am saying is they could have brought a very simple murder case against Mr. Stillwell many years ago.
Shout out to Law and Crime
They
Channel,
made
man.
the deliberate decision, the deliberate tactical decision to put it on this indictment with all these other individuals, with all these other overt acts, and with distinct rules of evidence that apply. So They did it.
Isn't that their choice? I mean, they're the state. Isn't that their choice in terms of prosecution?
It is their choice,
I mean,
but it doesn't make it right.
it's not the
They're
way
arguing
Max
one.
Sharp would have prosecuted this case if you were the district attorney. You would have probably prosecuted just like that, right?
I don't know what I would have done. That's
Okay,
why I'm
but
not a
they-
DA, but and I never will be.
All right.
But Your Honor,
All right, well
I will say
well
though
said,
that
okay.
they triggered this with the
Sure.
arrest, and then they decided to make this one incident a very complex, a part of a very complex case, and that was their deliberate decision, and they knew that my client had not only a right to speedy trial, but had asserted
You
his
talking
right
about
to
the
a
dude
speedy
right there
trial
with it?
when they made this
Right straight
decision.
ahead right there.
And that's the problem. Thank you, Your Honor.
You're very welcome. All right, Mr. Armstrong, finally got your name right. Sorry, I apologize. Might just be back in contact over the past several years.
Absolutely, Your Honor.
Been a long day, but go ahead, sir.
One thing I'm going to go in the order of the analysis. So one thing I wanted to begin with, because both the court and Mr. Shard assumed that I conceded a certain thing, but there's a nuance to it that I wanted to draw out for the court. Mr. Shard isn't simply attacking count 2. He's
Oh, got
attacking
them
count
big
2
lawyers, boy.
and any count upon which is predicated on count 2. That's a coy way of referring to count 1.
Yes.
And so you have two different issues, and I submit to the court that those are two different speedy trial clocks. Because the RICO conspiracy is the entire conspiracy, which extended into this year to include the murder of.
Count 2 is the dog factor for four factors. What about count 1?
Count 1, we have not reached the threshold yet because with the conspiracy bled into this year. And I've cited an Ohio case because there's no Georgia case that has decided the issue. But essentially, you go from the arrest or indictment for RICO.
Well, it's like
which
some
happened
mob
this
shit
year,
right here,
when
boy.
you're dealing with the RICO conspiracy itself. And
No
so because
joke.
they're making claims against both count 2 and count 1 as something predicated on count 2, those are going to be separate analyses for the length of time.
Is that state versus Messer 207, Ohio, 5899? You cite that for that proposition?
Yes, Your Honor. And I would just like to be
Speedy trial timetable for the RICO charge begins to run upon the date of the defendant's arrest for the RICO charge itself, not upon the dates of arrest.
Shout out
for
to
the
Law and
predicate
Crime
That is
Channel,
correct,
man.
Your Honor. And I'd just like to be clear that I did not
Like,
select
share, and
the
subscribe.
best case for me. I
Like,
looked
share, and
through the entire
subscribe.
nation, and it doesn't seem that I could find any other case, any
CMD,
other court that had addressed that
CMDA,
issue. This is the one
GOAT,
court that I have that
CMD
had
GOAT.
addressed that issue.
on
All right.
YouTube.
And so I wanted to make that distinction that even if the court were to find something as far as count 2, it would not apply to count 1, and the case would still proceed with the information in count 2 against Mr. Stillwell. The length of the delay, the court has indicated that the court was going to hold up benignly against the state. I've made my arguments in the brief, and so I'll move on from that. The cause of the delay, you heard Mr. Sprinkle, Deputy DA Sprinkle testify here today. And that was the reason that we brought in his testimony, because Mr. Sharp did not make a specific allegation that the state had intentionally acted to gain a tactical advantage and hamper the defense.
Do you want to break down the time periods so to account for them?
Yes, Your Honor.
I think you've got 27 October 15 to 13 November 2018. And then you've got another period of 13 November 18 to May 9, 22, and then May 9, 22 to present.
Correct. So I divided those times this way for this reason. Because Mr. Sprinkle had the large 140-page summary of the investigation as far as the case was concerned. That's a very, very large summary. That's not a summary that I've seen before, that length of it. That's the complexity of just the murders, I understand it. And so I wanted to draw that period of time because we have not just the live testimony, but his adoption of more details that are in there to show the scope and what was going on in the investigation, shows the justifiableness of the investigation. From the period beyond that, we don't have a document to hand the court, but you heard Deputy DA Sprinkle testify about ongoing investigation, ongoing work with different prosecutors, and as the court noted, basically realizing that this was a large RICO conspiracy and trying to put all the pieces together and moving forward for that. I also want to mention that during that period of time was the COVID shutdown, which affected every part of the criminal justice system. And so I didn't want the court to we have not been dealing with perfect normal times throughout this entire process. From May 9th, 2022 to the present, that was the date on which the original indictment came down, assuming that I have the correct date. From that point until now, everything has has moved forward appropriately. There's been no unjustifiable delay. It's basically been a regular case. You've gone from May 2022, we are now in December 2022. That's 7 months and we're at the precipice of trial. That's a very, very quick turnaround. So I suggest to the court that that is an entirely appropriate delay that shouldn't be weighed against either party. But the main thrust of it, and I believe I heard you discussing with Mr. Shark this, the state submits that it was a justifiable delay in dealing with the investigation for this case. The individual murder itself was complex to investigate, including original assertions that turned out to be false. And you have it being clear from the beginning that it was the precipitation for an ongoing set of violence between two rival gangs, and that ultimately became part of the RICO conspiracy. There is a case for the length of the delay that I cited, I think is also relevant for the cause of the delay, where I discussed there's a Georgia Court of Appeals case that had a 12-defendant RICO case that had a smaller number of predicates, where they said that that's the type of case that justifies a longer investigatory delay than a more simple event that doesn't have that conspiracy going on. Now, this will be, I did want to mention a few things about the third factor, which is the assertion of the right. I'm going to address an issue first that's a little bit more specific. I would normally begin more globally, but you were talking with Mr. Sharp about statutory speedy trial demands. That's not what I'm hanging my hat on. However, I interpret the rules, including Judge Brasher's statutorily approved pause of the statutory speedy trial demands, very differently than Mr. Sharp does. It is not something you can't file. It simply says the time the state has is paused until the January term of court for 2023. It doesn't say you can't file it. And I don't know who he's referring to who says you're not supposed to file it. I've not heard that. I'm not aware of anything of that. When I read the order, I fully expected the statutory speedy trial demands to keep on coming, just that they would not have their time towards the clock run as far as what the state has to do to meet them. And so Your Honor was interested in hearing what I had to say about those. That is one bit, because he couldn't file. Let me back up for a second. Mr. Sharp had made representations in the brief of what he could or could not do.
He could have filed it. It just wouldn't have taken effect because the delay. I mean, Judge Brasher's order and the Supreme Court of Georgia's order told those until January 1.
Correct.
So they would go live on January 2nd of 2023.
Absolutely. And so the fact that he didn't file a statutory speedy trial demand is something that I just include based on the demands for trial that are made this year. One of the things that the court is going to be looking at is the vigor and the strength with which the assertion was made. And that leads me to the other issue, which is Mr. Sharp mentioned in both of his motions to dismiss the original one and the amended motion that he could not have filed a former demand for constitutional speedy trial without an indictment. That is absolutely false. You can do that the first day of your arrest if you want to. And in this case, that actually happened. I submit to the court that since he filed on December 13th the amended motion, and given how it reads, where it asserts that he can't make a formal demand for speedy trial, and where he does not mention the 2019 assertion, I assert that if the defense doesn't even know they've made an assertion, it's not a strong one. The 2019 motion, it was not mentioned in his filings. It was not mentioned in Ms. Rosenwasser's original response to the court. And I found it last night. I had 3 copies to bring it, but it seems that Mr. Sharp has found it in the past week to mention it. The document itself, I'd ask the court to look at the certificate of services off. It doesn't seem normal. And so we don't know exactly whether they filed it correct, what they did, because they just say this hypothetical other things. And so I just want to mention that, because no one in this case was aware of that demand for speedy trial until this week. There's no one who indicates that they were aware of this. Why wasn't this a part of the motion to dismiss that was made months ago if the defense was aware of it? So I just mentioned that because we are now aware that there was the demand for speedy trial. I don't know if anybody was aware previous to last night when I discovered it, as far as the state is concerned. And so I mentioned that for the strength and the vigor with which the assertion is made. Now, I do not contest that the court has to weigh in some way the period of time since the demand, because the demand was weighed. But the issue for the court is how to weigh it. And I submit that it was not done. It was a very, very weak assertion of the right. However, as the court identified in speaking with Mr. Shart, the period of time leading up to that in which he absolutely could have filed a constitutional speedy trial demand is something that I think you should weigh against the defendant, because that is a number of years for which he would have been charged with murder, which goes to his ultimate claim about the length of time. Now, I would like to move on to the fourth prong, which is the one about prejudice. And the whole reason that you go into the Barker versus Wingo factors is to see if seeing those four factors as a whole outweigh the presumption of prejudice that occurs from the length of time that gets you to those factors in the first place. There's been no showing of any demonstrable harm, and I'll explain both of those things. I showed my work in writing the state's response that I was able to file today, and I would just like to confirm what Mr. Shart said. He did not see the brief before today. I became involved yesterday when the trial team was unable to make a response in time for today's hearing. And so I showed my work in the procedural history of the case to describe all the periods of time in which the defendant has been in the Fulton County custody since his arrest on October 27th of 2015. That period of time that he was originally in the Fulton County jail through that date to part of 2016, he was also in jail for other charges. And when he pled guilty to those other charges, as cited in the state's brief to both
I think you're talking about the co-defendant right now
that are within the court's records on Odyssey. Every day of that was attributed to something that he got credit for time served for on the 10-3 prison sentence that he received for that other case. He left Fulton County's custody to prison, served out his sentence, and at that point he returned to Fulton County and bonded out the next day. So that one day in October 2018, the full day, so it's from the 23rd to the 24th, so it might technically be 2 days, but it seems like just one full day. That's the only day that I can identify that the defendant was in the Fulton County jail for no other reason than the crimes associated in the incident in which Donovan Thomas was murdered. There are intervening situations in which the defendant entered our prison under new charges and either resolved them or simply left the jail without them being resolved over that period of time.
When they say Donovan Thomas, they talking about Big Nut.
Again, I've cited the Fulton County case numbers that apply to them
Big
as well as
Peanut.
the jail booking records
For those who
that this court has
don't know,
access to through Odyssey.
he used
On
to be
March
with
17th, 2022, the defendant
YFN
entered the
Lucci.
jail once again. That's what he's currently been in there for.
That's I think
And that was
if I'm not
for
wrong,
the
I think that who put
separate additional
YFN Lucci on.
of Scheinel drinks. And since that point in time, he has been in custody that entire time
your
to this
research.
day on those charges, as well as any other charges that he may have. The relevance for which I bring this up is that, number one, the court said that any pretrial incarceration is prejudicial under prongs. That's not entirely accurate. It has to be oppressive pretrial delay incarceration. The courts have determined that simply being in jail does not set it apart from other circumstances. He has alleged issues about being stabbed in the jail this year, but there's no evidence that was presented to the court about that. I'm not personally.
I think he's talking about YFN Lucci
I'm not
now.
saying that it didn't happen. That's not something in the record currently before the court. What's important, however, is I cited case appellate courts, primarily the Georgia Supreme Court, which collects Sal Lahuden, Treadwell, Dagenbaugh, and I apologize to the court reporter for the spellings of every one of those names, as well as Cawthorn, where essentially, if you are in custody for something else, that cannot be oppressive pretrial incarceration for the purposes of Barker versus Wingo for this case. And other than that one day in October 2018, I'm not aware of any point in time in which Mr. Stidwell has been in the Fulton County jail for no other reason than the murder of Donovan Thomas And so I wanted to point that out for the court because he's not shown demonstrable prejudice in that regard. Now, the death of a witness is
So
absolutely
you talking
something
about
that
Donovan
is
Thomas?
a concern.
That's big
something
nut,
that comes up
big
in
peanut.
constitutional speedy trial cases.
One that got murdered.
However, in this particular case, the issue is it's essentially speculation as to what she would say otherwise. We have the fact that she said that her husband was a liar and that he was unreliable.
Okay, we're gonna stop it
We
right
have
there,
that.
man.
It is literally
And
recorded.
end it, and we're gonna catch
And
the
so,
next one.
as the court noticed, we don't know at this point in time if the state's going to call that
So I
particular
appreciate
individual,
everybody logging in, man. And tapping
the
in with
relative
me.
of Mr. Sidwell.
Like,
We don't know
share,
if
and
we're actually going to
subscribe.
call that specific
CM
individual when it comes time for trial.
GOAT, the
However,
GOAT
if we
on
do, the
YouTube.
defense has
Shout
the
out to
statements in which
Law
she
and
literally
Crime,
said those
Law and
statements that they
Crime
know of.
on
They have
YouTube
a
too.
recording of that,
So
and the state
gonna
offers to
end it right there,
stipulate
man.
that will be admissible
we're gonna end it.
against, in Mr. Sidwell's case at least,
We're
for the purposes
gonna always stay
of
covering.
dealing
We're
with.
going all the way into
the-
2023 on covering it.
I apologize. Is it Jerron Sidwell? Tremaine Sidwell. I apologize. I got confused as to who was speaking with. It's Theron Sidwell.
Just for the record, I think I need to say this, we do not feel that the offer stipulation is sufficient. The reasons I say.
Okay, that's fine.
And so getting in that information is something that they would be able to do. It was my understanding from reading their brief that they were saying that they couldn't call her to impeach the relative.
If he's called.
Pardon?
If he's called.
If he's called, correct. And so that's why I cited case law that indicated that the potential prejudice from the death of a witness is alleviated when the state offers to stipulate to the information that they would have been able to get in otherwise.